Thank you very much. First of all, thank you, Mr. Director, for your introduction, and thank you very much for your invitation. And my congratulations for this initiative from Luxembourg. I'm sitting now in Luxembourg. First of all, I would like to tell you that I'm not a family lawyer, first of all. I'm professor of law, private law, and compulsory law, but I had to teach before also family law, and I have some interest in the family law. In my short presentation, I would like to give you a short overview of the cases which I found interesting to you as a non-professional professor of law. As you know, the regulation of the personal status and the family status, falls within the competence of the member states, and the EU law provides some special subjects, some special regulation, and these fields are quite different. Probably the most important, if I can do some ranking, this is the exercising of the free movement and residence, and the directive and the case law on this EU legislation. The second one is very important on the directive and the practice of the reunification of the family. Probably the third group is the coordination of social systems. In connection with some cases are very important, how the Court of Justice interprets the family and family relationship. Of course, in the private international law and international procedure law in connection with Rome through and Lucerne through this, there is a huge case law. From these topics, I chosen only a couple of them. First, regarding the Citizens' Rights Directive, the first set of cases consists of cases of preliminary rulings related to the interpretation of the Citizens' Rights Directive. The Citizens' Rights Directive provides the detailed rules on the free movement of EU citizens and one of the fundamental law on the details of the right to enter and reside freely in other member states, citizens and their members, the family members. The scope of application is the migration of the EU citizens and their family members across the border within the Union. In the major change in the application and interpretation of the directive means that the free movement was not more linked to the economic activity of the related person, but became one of the fundamental rights of the EU citizenship. This is the Article 20 of the Treaty of Function of European Union, which has created the EU citizenship as a fundamental right to free movement and residence enshrined in Article 21 in the treaty. And the Citizens' Rights Directive provides the detailed rules to this basic two articles from the treaty. As that is a fundamental EU law, the paramount picture importance of the case law and in many cases goes far beyond the application of the directive, since the interpretive powers of the Article 21 are much more wide. As you know probably better than me, in 2011 it was a very important ruling on case Zambrano, which concerns the residence of the third country national in the member states. One Colombian couple get a second and third child in Belgium because they was Belgium asile, but these two children acquired Belgian nationality. The question was whether, in relation to the children with EU citizenship rights, parents should have also a rights for reside and stay in Belgium based on the rights of the child. The right of the parents is arising from the rights of the child as EU citizenship. The court's reasoning was based on the interpretation on the application of the EU citizenship, not only by the reference and application of the directive. The court went much more further. The right of the parent through the EU citizen child has been recognized by the Court of Justice on the basis of Article 20 of the treaty. Article 20 precluding national measures which have the effect of depriving citizens, in this case the parents of the Union, of the genuine enjoyment of the substance of the rights. If the child is an EU citizen, the father and the mother of the third country citizens cannot be blocked by a national rule, in special case the Belgian legislation, deprive for residence and employment, such a state measure is contrary to Article 20. The genuine enjoyment formula, which was introduced in this case, was developed in three set of cases, in McCarthy case and the Deretzi and all case. One is in UK and the second one from Austria. But 2017, there was a very important cases from Lunes, as I pronounce properly. Ormazabal is the Spanish national traveled to United Kingdom and later on acquired British citizenship. There he married an Algerian who entered into the UK with visitor's visa and stayed in the United Kingdom illegally. The ruling follows the logic of McCarthy judgment, since Ormazabal is also a British national and is not concerned with his residence in UK, and his person has no connection with the application of the Citizens' Right Act, because he was a static citizen. Do not use his right of free movement, but he stay in the same country where he was resident. The court said that in this case, the Citizens' Right Directive, which relates for the free movement, it cannot be applied, because the EU law does not provide for any independent right or entry or residence in respect of the third country national of the schools. This is out of the scope of the directive. However, the ECJ recognized the static EU citizens like Ormazabal, who does not exercise the right of the free movement, but it is a disadvantage vis-à-vis a non-static citizens. The moving citizens should have more rights than the so-called static citizens in connection of the marriage with a third country person. It will also follow that union citizens who have exercised their freedom of movement and acquired the nationality of the host member state, in addition to their nationality of origin, so far as their family life is concerned, be treated less favorable than union citizens who have also taken this freedom but who hold their nationality of origin. The ECJ allowed the scope of application of the Citizens' Right Directive in such a way that Article 21, the Treaty of Function of the European Union, granted a wider application of the Citizens' Right Directive. That through Article 21, the directive was applied a larger sense. And this is why, and the court said, it should be applied by analogy for such a cases as was Mr. Ormazabal. The real, I would say, very interesting question or cases came from 2019, as you know, probably in connection with an Algerian kafala judgment. The child placed under Algerian kafala, and the question was for two French citizens residing in the United Kingdom. They went to Algeria, and then asked the kafala, and they get the right, and even the name of the child was changed to the parent's name. The question was whether this child can be traveled to the EU and can stay in the EU with his new, I would say, guardians. The question was whether the child under kafala should fall under the scope of the direct descendant based on the application of the directive. The directive Article 2.2 defines the term. This is what does it mean? What should mean family member? And it says the direct descendants is using this terminology. If I understand the decision correctly, the concept of direct descendant must be interpreted in the light of the personal law applicable to the person under the state law. But if the child and parent are different, this qualification is not clear. So the ECJ2 did not look how the law of the member state defines, but gave an autonomous concept of EU law regarding descendant or direct descendant. The court concluded that parent-child relationship must be construed broadly. Broadly what means so that covers any parent-child relationship, whether biological or legal. The legal should mean that the adopted child is such a citizen, since it is established that adoption creates a legal parent-child relationship between the child and the parent. But the court concluded the kafala, the Algerian kafala, does not establish a parent-child relationship between the child and its guardian. Therefore, the child cannot be considered under the directive. This is a direct descendant. But the court went further and then looked Article 3, paragraph 2, subsection A, regarding the so-called a larger member of the family. And then from so-called a wider family circle, which can be found in this directive. The derived right to enter and reside of such persons who fall under the terminology and definition of the so-called wider family member shall be facilitated by the member states to make possible to enter into in the member states and to stay there. The ECJ concluded that the concept of other family member, which should be other family member, is not spouse, not a direct descendant, and not independent relatives, not direct relatives. The so-called any other family member should be also allowed to use his rights or his or her rights regarding this from this relationship. Given that the member states' discretion in the application of the directive was called upon in point 32 recitals of these directives, which mean that the charter should be applied at the Court of Justice. And from the charter, application of the charter, application of the Article 21, application of the directive, from these three sources of law, the court concluded that the guardian relationship based on the kafala should be accepted by the member states, especially taking into account of the Article 24, paragraph 2 of the Charter, which provide a special rule to take into account of the best interest of the child by the application of the EU law. The ECE does not say that it is necessary to examine whether actual family life already exists between the child and the parents. But this can be also an important element to make a decision whether under the kafala, the child under the kafala should be regarded as another family member under the application of this directive. The factual situation is to be considered, or the likelihood that the child under the kafala and his guardian will live in the family life may be sufficient to allow entry and residence in the EU. This is confirmed according to the ECJ ruling, but the fact that in the absence of this, the family life previously established in the EU citizens concerned would be hampered by the fact that one parent guardian would have to remain caring on the child in Algeria. That the logic is here, they return, they already a couple, they use his right, and if the child he was accepted by them as a kafala guardianship, if they cannot use this right, one of them should be stay in Algeria with this child. This would also violate they already acquired right. But I do not want to discuss all consideration about the kafala judgment. Probably I would like to make one point. In the ruling, we can see the formulation. On one hand, family life, and other becomes the family. Or these are synonym notion or not. This is, I would say, should be discussed much more broadly and much more details. But it seems to me that the living together with members, it can enforce the acceptance, very interesting, from legally acceptance that the existence of the family. Another observation is that the pull force in the child's right, the best interest of the child moves the interpretation of the law to a broader sense, protecting the child's interest through this channel, the application of the application of the so-called other member, it can be enforced. That through Article 24(2) of the Charter, through this protection of fundamental rights protection, the family, I would say the de facto family, sometimes it could be also by protected. You know better than me that the kafala we already know in the New York Convention. You know we have a huge case law, private international law, but the ECG do not refer it. They do not use what already is available, I would say, in the European level about the kafala. What I can see here that in this case, the Algeria kafala, the status of the so-called extended family member or other family member requires both legal relationship and factual relationship. But legal, this is the Algerian connection, which is somehow is creating a guardianship, which is limited in also in time, but it's a legal. On one hand, factual elements. Whether these two conditions will be followed in the future, we don't know. The fourth case is, I would like to mention very broadly, this is a common judgment, you know, the Romanian judgment from 2018. The recognition of the right of the residents of the same-sex marriage spouse with third country nationality in the member states. The Romanian authorities did not grant a residence permit to the Mr. Corman's third country national spouse as a same-sex spouse because Romanian law does not know the same-sex marriage. Whether other grounds could be made probably available, it was not clear for me. But only based this legal relationship, it was refused, and the case was go even the Constitutional Court, and the Constitutional Court made a preliminary ruling before the Court of Justice. The very probably for me, it's an important element of the decision that the ECG fixed that the concept of spouse among family members is defined in the directive, the same directive, is to be interpreted in the gender-neutral way under the directive. Probably this is the most element from the application of this directive. The regulation of the personal law falls within the competence of the member states. This is accepted. It is up to the member state to decide how to regulate this matter. The ECG, on the other hand, points out when deciding on this issue, member states must take into account the rights of the free movement and residence of EU nationals. After having considered Article 21 of the treaty and Article 7 of the Charter, the Court concluded that the regulation of the status of the persons falls within the competence of member states. But the right to continue a family life established one member state, in this case, the same-sex marriage in other member states, however, is protected by the Charter under the interpretation of the EUCG, and there is an additional legal protection is Article 21 of the Treaty Function of the EU and the European Union. In other words, the living family life is recognized and protected in such a way that the state of nationality may not deny same-sex spouse the right of residence. With other formulation, if these rights already acquired, this is a protected right in one member state, these rights became a vested right. This right that they already used as living together as a marriage couple, it should be accepted in other member states in the related case in the Romanian court. And then the court made some reference on the practice of the European Court of Human Rights, and who already accepted that the homosexual couple should be protected in the same way. We have, you know, in the Charter, we have a link between the practice law, the causes of the European Court of Human Rights, those who should take into account in the application of the Charter. And this is how the result came out, that through Article 21, through Article 7 of the Charter, and plus to a new right, the right to be a right to continue the former marriage, acquired marriage legal status in other member states, introduced a very special, unique case saying that in respect of the EU law should be accepted. There's no more. Which means it's very interesting that probably this marriage is accepted in certain level under the application of the EU law, but the member state is not obliged to accept this as a whole. Probably this was my interpretation. Regarding the family reunification clause, I have also cases, but I will jump two other cases. It's also an interesting case in connection with the Rome III, the so-called recognition of the Sharia divorce before the German courts. It was very interesting because it was a Sharia divorce in Syria, and it was affected by the unilateral declaration of the husband, and the wife is accepted, but then the husband wanted to recognition in Germany, and the German authorities accepted this divorce as legally affected. But the wife, or the former wife, is attacked that such religious divorce should be not accepted under German law, and they were sent to the question to the preliminary ruling whether the acceptance or recognition, I would say recognition of such judgment is fall within the Rome II or not. It was two cases, the second one. But the court drew is the conclusion that based on the interpretation of the Rome III and wording, context of the regulation, and also taking into account on the wording of the Brussels II regulation, that the recognition of the decision of the Sharia court and the decision of the divorce is not fall within the Rome III. It's very interesting. On the basis there is no EU law concerning religious, or some authors saying a private divorce should be accepted based on Rome III. What does it mean? It means that in lack of EU legislation, the member states should have a competence to make such rule. And in the recent cases, the Germans applied Rome III. One court applied the Rome III by analogy. Another court in München, it applied the old German rules for the divorce private international law, which was no more effect. It was quite interesting that this approach that shows that the application of the EU law should have also some limits concerning the private divorces. And last case, I would say very shortly, because I have no time, this is a staff regulation. Staff regulation. It's completely different than before. There's no preliminary ruling, no abstract interpretation. The question was whether who are entitled for pension, European pension, under the European law. In this case, it was a marriage, but the widow has a marriage relationship with the EU functionary. It was less than 1 year, and the staff regulation, there is a very clean rule. If the marriage should be invalid and should be at least 1 year marriage is necessary to get EU pension. In the court's view, this is not arbitrary, is not discriminatory, because the demand for this EU pension was refused. Based on that, your marriage was less than 1 year. The applicant said, sorry, before the marriage, we already live together. We have cohabitation, we have partnership. You have to edit. It's like in Hungarian law, in the marriage, sometimes it's not the real milestone, the starting point of the marriage, of the legal point of the start of the marriage. The court said, no, we cannot accept, or we do not want to accept any kind of way of the similar cohabitation, even legal cohabitation, for EU pension funds. Only for this requirement should be taken into respect. What does it mean? Why? Saying first, the marriage should be at least properly living with content and with factual basis. A formal marriage is not enough. Second, we have to say in the court, the purpose of this 1 year is very clear, to protect EU funds and EU money, public money. And third one was much more The marriage cannot be replaced in this special case by other form of the cohabitation, neither by registered partnerships nor by simple de facto cohabitation, which is very, very interesting. I would say very interesting. This very narrow interpretation, but only for this so-called staff regulation. Some remarks very shortly. I would say, of course, in some cases I cannot make a big general overview, but it seems to me that the marriage remains legal relationship included in formalized way by the state, and the monogamy relationship that EU law is precludes accepting the polygamy. It's very interesting. But we have to, this is the factual case, but the court already decided or expressed that the marriage is a gender neutral in the European way. However, if you look at this ruling, it's much more an obituary victim than it can be followed. The marriage itself qualifies the family, a so-called family, a nuclear family, a small family, core family. But if there is a child in connection with this spouse, then it's a family, it's much more better protected. I would say the family members are better protected, or the family members have much more, I would say, additional rights for social benefits, for staying, for using the EU rights. The private religious divorce is not accepted, as we saw from this case. I would say not yet. And the European level, probably we see some draft to change it. However, the EU recognized several models of cohabitation, reciprocal and form in some case law and some legal rules. They do not accept. They make very clear distinction between marriage and other form. And probably the most important, interesting, that the child. If there is a child, the child puts much more force to this right. The child is who is probably they increase the level of the family, the protection of the family, which I would say the positive side of this approach. That even with the family with the child, it creates a real, I would say, a better place, even for better protection, even for the parents. If the child is under kafala, we say it's okay, it's not descendant, but still family member. Which for me, it's very unique to say this is other family member, but this is accepted. Whether the whole picture, I cannot say about how does it work, because there's a lot of case law, especially the social benefits. But I would like to thank you for your attention, and probably I can, every question you can give me. But once again, I'm not a real expert on this. Thank you very much.